Hi guys, welcome to my live stream on YouTube Live, and today I will talk about the law on sales and the law on lease. So kaka-start pa lang natin. We'll just wait for more students to and more viewers to come in and join us. Okay, hi Francisco, kamusta? Nahirapan ka ba sa exam? Okay, by the way, the bulk of our viewers today will be the members of the free online law school of the Philippines. And this is, of course, a web or a Facebook based group of students, law students, and even bar reviewees. And we're here to help and hopefully ma-reinforce yung kanilang natutunan about the law on sales and the law on lease. Okay, so this lecture will be good for 2 hours, and we will start with sales, tapos we will continue with lease. Actually, this is the first of 2 lectures. The second lecture will be tomorrow, God willing. So tomorrow I will discuss the law on loans and deposit. Okay, so ayan. So far ilan na ba? Ayan, 5 na. Okay, now I invite everyone to write your comments, and if you have any questions, then I will of course try to answer questions in between breaks, and of course in the course of the lecture. Now, if you are new to my page or new to my channel, this is the House of Law. I use this medium to make videos and share my knowledge about the law, about law subjects, and about law-related issues. And from time to time, I also make travel videos and post them on my channel. So, dun sa mga hindi pa nagsasubscribe, please subscribe to support me, at saka para at least you will know if I upload a new video. Now there's a feature on YouTube which gives you real-time notification or announcement, and that is by clicking the notification bell, you will be notified in case I upload a new video. So hi June. Ayan, si June talaga hindi uma-absent basta may live ako. Hindi ko pa nakukuha yung pasalubong mo from Siargao, but I will contact him. Nag-message na siya, hindi ko pala siya nasasagot pa, no? Okay. So nasa na si Ma'am Rose? Ayan, Ma'am Rose, are you here? If you are here, please comment, please say hi. Thank you for the idea and for the suggestion, and I am more than happy to help your group, especially on these topics. I know your group has already invited a lot of lecturers from Judge Didong, and also Fiscal Luna, but of course they are experts in their fields. Like the case of Judge Didong, of course he is an expert in political law. Of course, Prosecutor Luna, being a prosecutor himself, is also an expert in criminal law. Okay. So tayo naman ay nag-expertan. Joke. Okay, so by the way, for those who are not known to me or who do not know me yet, I am a lecturer in law schools. I teach at FEU, University of the East, Adamson University, and Lyceum of the Philippines, Cavite and Makati. I also lecture at Jurists Bar Review Center, Legal Edge, Academicus, VLC, PUP Bar, and they mentioned Legal Edge. Yes, Legal Edge. And so we try to help as many law students and bar examinees as possible, so that of course they will be able to reach their dream of becoming a lawyer. Okay, so what will be the goal of this topic? Well, the goal of this lecture is to teach you the basics of the law on sales. We will also look at the controversial aspects or issues of the law on sales, and also hindi mawawala yung mga decisions ng Supreme Court which are relevant to the subject. Okay, so Hi to Jessie Fuentes, who's watching from Bohol. Ayan, I miss Bohol. I was in Bohol 2 years ago. And so, nakakalungkot, no, because of the pandemic, hindi na ganun kadali pumunta dyan. But, soon in the immediate future, makapunta ulit tayo dyan. So, June, pasalubong from Bacolod, Butuan, Davao, Siargao, Surigao, lahat ng place ng pasalubong ka. So, pinagsama-sama mo yung mga pasalubong. Okay. Naku, hindi naman kailangan nag-abala ka pa. But, thank you. Okay? So, ilan na? Ilan na tayo? Okay, we are 13. So, I invite you all to write your comments. Just so I would know where you're coming from. Please tell me where you're watching this live stream from. And then, if you like, you can also make a shout out to your school or to your friends. And then, I'll try to mention them here to read your greetings. Okay? By the way, sorry for the delay. I was supposed to start at 1 p.m. but because I had class until 12 noon kanina sa Adamson University, I had to set this up. But hopefully we can finish maximum of 2 hours. So I promise to end by around 3:30. Now, of course, you can have a break if you like, but you can listen to the live stream on the background. Kasi this lecture is both visual and auditory. So even if nakikinig lang kayo, hopefully you can also learn from this lecture. Okay? Now, for those who are not familiar also of my Facebook page, I have a Facebook page. It's called Attorney Al Jumrani. You can also follow me there. So if I have updates about the law, or I prepare some videos or articles, you can find them there. But for videos, mostly I post them here on YouTube. Okay, sige. Ayan, 17 na. Okay, so with that, we can start. Alright, so what is the law on sales? The law on sales is part of the Civil Code, particularly Book 5, and Book 5 refers to the special contracts. There are a number of special contracts, but the most common is, of course, the law on sales. And this is common, and I think the most relevant because everyone has engaged or will be engaging in sales. Most probably today, may binili ka or may binenta ka, whether it be food or whether it be some personal items or consumer goods. Everyone has had an experience in sales. The law on sales applies to simple purchases such as I said, food, or complicated or complex purchases such as purchase of real estate or even purchase of intangible goods like shares of stocks. Okay, but the rules are the same. The basic principles are the same. So if you know and if you master the law on sales, then it will at least help you deal with the complicated issues later on. For example, issues on land registration, issues involving commercial transactions, like e-commerce, for example. Okay, so it's important that you have a very strong background on the law on sales. And this subject is taught on in the second year in law school. Now, in the fourth year, this subject is part of Civil Law Review 2. But in the bar exam, of course, the law on sales is just one of the many subjects that you will have to deal with and study for the second Sunday of the bar, which is in the morning of the second Sunday of the bar. Okay? Because civil law exam is scheduled in the morning of the second Sunday. Now, what are the chances of sales being asked? Of course, it's from 80% to 100%. There will always be a question on sales. But as to how many, yan ang depende, no? In some bar exams in the past, merong 3, merong 4, ganyan. Meron ding times na talagang isa lang, no? Because depende talaga doon sa examiner. The examiner may be an expert in family law or personal law, so kaya mas marami siyang tinatanong doon. But if your examiner is one who is into contract law, then expect many questions on sales. Now, even if the examiner is into property law, for example, land registration, um, purchase, as well as donation of properties, then meron pa rin talagang pumapasok na tanong on sales. So, hindi pwedeng pabayaan natin itong law on sales, no? Akala nyo madali lang or akala nyo very basic, so you can just rely on your stock knowledge. But no, the law on sales, despite its being very elementary, can be very tricky as well. Okay? Sige, so let's begin. Okay, hindi lang daw maka-comment si Ma'am Rose. Okay. Alright. So what is a contract of sale? So the definition of a contract of sale is found under Article 1458 of the Civil Code. And in a contract of sale, one of the contracting parties obligates himself to transfer the ownership of and to deliver a determinate thing, and the other to pay therefore a price certain in money or its equivalent. Now, my tip is always to dissect the definition, and the definition itself can provide you very important insights about the law or about the contract. So as provided in the definition, a sale is a contract. So you have to, rely on your background or stock knowledge about a contract. So when you say a contract, then a contract is an agreement between two persons. And in contract law, these two persons are called the obligor or the obligee, and the creditor and the debtor. The obligor being the party who has the duty to perform something, while the obligee is the party who has the right to demand the performance of the obligation. Now, in a contract of sale, the parties are called the seller or the vendor and the buyer or the vendee. So, sino ba dun sa dalawa ang obligor at saka obligee? Well, because a contract of sale is a bilateral contract, so both of them are obligors and obligees of each other. Both of them are creditors and debtors of each other. Although you will notice that this definition seems to be only one-sided, no? But technically speaking, it really is a two-sided contract. One has the obligation to transfer or deliver a thing, and the other has the obligation to pay a price certain in money. Now, the other thing to note in this definition is that the subject of a sale must be a determinate thing. Okay, so it's something that is to be delivered. So services cannot be the subject of a contract of sale because it's not something to be delivered, but rather service is something to be performed. Okay, so hindi pwedeng sabihin na I'd like to buy your services. So instead, you say you want to hire the services of the person. You don't buy the services of a person, because that other person will not deliver his services, but rather he will perform his services. Okay, now the other thing to remember in this definition is that the obligations of the seller are to transfer ownership as well as to deliver the thing. We will talk more about these obligations when we talk about the vendor. Also, the last thing to note is, or maybe the second to the last thing to note, is the obligation of the buyer. And the obligation of the buyer here is to pay the price. Now, the last thing is, of course, that this price is certain in money or its equivalent. It's not another thing in exchange for the thing to be delivered by the seller. Because if it's an exchange of things, then it's no longer a contract of sale, but rather a contract of barter. Okay, so that's just preliminary. Let's now go to the essential requisites. The essential requisites of a contract of sale are consent or meeting of the minds. The second element is a determinate subject matter, and the third element is the price certain in money or its equivalent. Now let's study in detail these three elements. But before that, okay, let's first look at the types of a contract of sale. So there are two types of a contract of sale as provided under Article 1458. First is the absolute sale and the conditional sale. So what is the difference between absolute sale and conditional sale? An absolute sale is a sale whereby the transfer of ownership is not subject to a condition. the ownership is transferred upon delivery of the thing. So even if the price is payable in installment, but if there is no condition or reservation on the part of the seller that he will reserve ownership until full payment of the purchase price, kung walang ganong condition, then the sale is absolute and the ownership of the property is transferred upon the delivery of the thing. A conditional sale, on the other hand, is a type of sale whereby the transfer of ownership is subject to a condition, and the non-performance of that condition prevents the obligation of the seller to transfer ownership from arising. In other words, kailangan mo nang gawin or kailangan mo nang matupad yung condition before the seller is bound to deliver the thing and to transfer ownership. Now, what are these conditions? Well, generally, the condition relates to the payment of the purchase price. So, most of a purchase or the sale of real estate properties involve this kind of condition, and that condition is to pay the purchase price before the seller or the developer will transfer ownership. Okay, so conditional sale yon. But there have been other cases or instances when the condition relates to a thing or an incident other than the payment of the purchase price. For example, in the case of Romero versus Court of Appeals and Lim versus Court of Appeals, the condition there was the removal of squatters in the property. So the parties entered into a contract of sale of real property. However, the property was occupied by squatters. So ang sabi ng seller, I will first remove the squatters before I will transfer ownership to you. And similarly, sabi rin ng buyer, o sige, alisin mo muna yung squatter before I will pay the balance of the purchase price. So the conditions there are twofold. One is removal of the squatters, and of course the payment of the purchase price. So the parties are free to stipulate and agree on conditions. And if you will remember our lecture on obligations and contracts, conditions can be suspensive, resolutory, for as long as these conditions are not contrary to law, public policy, or public morals, then these conditions are valid. What is important is that both parties agree on these conditions, and these conditions must first be performed before the obligation of one party to the contract will arise, whether that condition is imposed on the obligation of the seller to transfer ownership or the obligation of the buyer to pay the purchase price. Okay, now, a conditional sale is further distinguished from what we call a contract to sell. Now, ano ba pinagkaiba ng conditional sale sa contract to sell? Well, very minor ang difference. They are both the same in the sense that ownership will transfer to the buyer only after the fulfillment of a condition, which is usually the payment of the purchase price. But the difference is that in a conditional sale, upon full payment of the purchase price, the ownership will automatically transfer. In a contract to sell, however, the full payment of the purchase price will not automatically transfer or will not automatically result in the transfer of ownership. Instead, the seller has to execute a deed of absolute sale. So that's why in some cases of the Supreme Court said a contract to sell is merely an offer to sell. So the conditions must first be met for that offer to become or to ripen into an actual sale. Now, between conditional sale and contract to sell, the contract to sell is or provides more protection to the seller than of course the conditional sale, because in a contract to sell, as I've said, the seller has to execute another deed of absolute sale in order to effect the transfer of ownership. Now, in LTD, if you have already taken land registration or land titles and deeds, we discussed there. By the way, also lecture LTD with Villasis Law Center. So I have discussed there that in LTD, a contract to sell is not acceptable as a deed of conveyance for purposes of transferring ownership. So for example, pag may bumili ng property or pag may bentahan ng property and the contract that was entered into was a contract to sell, that contract to sell will not be accepted by the Register of Deeds for purposes of transferring title to the property. The proper deed of conveyance is a deed of absolute sale. Now, kung DCS naman ang ginamit nila or deed of conditional sale, the DCS, if accompanied by a receipt or an acknowledgement of full payment, that can be accepted as proof that the ownership has already transferred because of full payment. So kung ikaw ang seller, it's best to execute a contract to sell para there can be no doubt that this contract to sell cannot be used as a mode of transferring ownership, okay, to the buyer. Okay, so for more of the distinction, you can read the case of Ursal versus Court of Appeals. Ina-assign po yan sa law school, no? I hope your professors assign that case, Ursal versus Court of Appeals. Okay, so I have mentioned earlier the parties to a contract of sale, so you have the vendor and the vendee. Now, let's talk about qualifications and capacity to give consent. So as far as qualifications and capacity to give consent, it's basically the same, and that is the law on personality as well as capacity. By the way, I have a video on persons and the legal capacity. You can find it in my playlist under civil law. Okay, you can check my civil law playlist. I have other videos there, and one of the most recent videos I made was the law on persons, capacity, use of surnames, and even absentees. Okay, so we mentioned that a person can be either a natural person or a juridical person, and both of these persons can enter into a contract of sale. So if it's a natural person, then the natural person must be of majority age. And what is majority age? It's 18 years old. So any person who is at least 18 years old may enter into a contract of sale. He can be a vendor or he can be a vendee. Okay. Now, for as long as his legal capacity is not diminished or is not restricted by law, then he is free to enter into a contract of sale. What are the conditions or the instances when legal capacity can be impaired or diminished? Well, number one, in case the person is an absentee. So if he is an absentee, then his property will be subject to administration, and this is of course granted by the court, no, in favor of another person to manage and administer his property. So hindi niya pwede ibenta yung properties niya. Now also, a person who has been convicted of a crime which includes civil interdiction as a penalty, he cannot also sell property, notwithstanding the fact that he is already capacitated to enter into a contract. Ayan. So those are instances where a person, despite being capacitated to act, may not enter into a contract of sale. But these restrictions are temporary. For example, when the absentee reappears, then the administration of his property will be terminated. Also, when the criminal penalty has been served, then the civil interdiction will also be lifted, so he can now manage his property, he can sell his properties. Okay, now with respect to juridical persons, now it's a different thing. It's not reaching the age of majority, rather it is acquiring legal personality. Juridical persons acquire legal personality according to the provisions of the law that governs or regulates these juridical persons. So let's mention three common juridical persons. So we have private corporations, partnerships, and public corporations. Of course, private corporations are those corporations formed and created under the Corporation Code. Well, it's now the Revised Corporation Code. So a corporation can be an association of persons, or it can also be a one-person corporation. What is important is that these corporations must have acquired legal personality, and they acquire legal personality upon the issuance of a certificate of registration by the Securities and Exchange Commission. It's not the filing of the articles of incorporation, neither is it the creation um, of the association itself, meaning to say the meeting of the minds of the parties who created that, but rather it's the issuance of a certificate of registration that vests the private corporation legal personality. Okay, now with respect to partnerships, partnerships are created upon meeting of the minds. There is no specific form that is required, except in the case of partnerships where a part of the contribution is a real property or real properties, where the law on partnership requires that the articles of partnership should be in a public instrument, and attached to that public instrument must be or is an inventory of the real properties. Now, the Supreme Court said that this requirement of a public instrument is indispensable to the validity of the contract. So, yun yung exception dun sa rule na pag partnership, it's created by mere agreement of the parties. So, assuming that the partnership has met the requirements, meaning to say there is a meeting of the minds, and if there are real properties contributed, the articles of partnership is in a public instrument, then the partnership can now enter into a contract of sale, either as a seller or as a buyer. Okay, now public corporations naman. So these public corporations can be government owned or controlled corporations. They could also be instrumentalities of the government or your local government units. Now, iba-iba yung requirement or iba-iba yung batas as to the formation of these public corporations and as to when they will acquire legal personality. Normally, if it's an instrumentality of the government, then it acquires legal personality upon the approval of the law creating it. And when you say approval or the effectivity of that law, then of course we follow Tanyada versus Tuvera, no? So a law becomes effective after publication of the law. Okay, so basic na yun. So we will assume that this public corporation is created pursuant to a law that is already effective. So from the effectivity of that law, then this public corporation can now enter into a contract of sale. For for local government units, however, the local government code states that a local government unit acquires legal personality upon the constitution of the officers, meaning to say the chief executive and the members of the sanggunian. So if the local government unit is duly constituted, then that's the time that the local government unit can enter into a contract of sale. Okay, legal personality pa lang yun. Now, how about the authority to give consent to a contract of sale? Pag natural person yan, syempre, siya na yun. Siya yung magbibigay ng consent. Because after all, a natural person acts by himself, no? Unless, of course, he acts through an agent. If he acts through an agent and that agent is clothed with authority to enter into a contract of sale, then the agent can give the consent. But for public corporations are but for juridical personalities, I mean, these juridical personalities act through their authorized governing bodies. So for example, a corporation acts through its board of trustees or board of directors. A partnership also acts through its managing partner if one has been appointed. But if there is no managing partner, then all the partners will have the power to bind the partnership. Pag public corporation naman, it's the chief executive who has the power to bind the public corporation. So take note of these personalities or these authorized persons. So if the contract is entered with a person not authorized by the juridical personality, then the contract does not bind the corporation or does not bind the juridical entity. Okay, alam ko merong pumapasok sa isip nyo, pero paano naman yung sinasabi sa Article 1403 number 3? Okay, is it 14031 or 14033 of the Civil Code, which states that a person who acts without authority may nevertheless bind the principal if the principal ratifies the act. Well, of course, that's an exception, no? So, even if, let's say, the contract of sale is entered into by a person who has no authority, for example, a treasurer of a corporation, that sale can still be ratified if, for example, the board of directors of that corporation retains the benefits of the sale or partially executes the sale, no? So that means it has now ratified the contract entered into by the said treasurer, even though he was not authorized to enter into the contract to begin with. Okay, so just remember those requirements as to the capacity of the parties to enter into a contract of sale. But in some instances, however, there are persons who are not allowed to enter into a contract of sale, and this is what we call relative incapacity. And this relative incapacity is present only because of the relation or because of the presence of some circumstances, no? So who are these persons who are incapacitated to enter into a contract of sale? Okay, wala pa pala. Okay. So, well, number one, well, by the way, for reference, it's Article 1490 and 1491 of the Civil Code. Now, minors, let's start with minors. Minors suffer from absolute incapacity. Okay, but if the contract is entered into by the minor for the purchase or for the sale of necessaries, necessaries are those things, items, goods that are essential for the support of the child, then that contract is valid until annulled. In other words, voidable lang siya. So when a child buys food, that contract is valid until annulled. So how can it be annulled? No. Well, actually the law uses the word annulled, but then medyo mali yung annulled because pag sinabi mo kasi annulment or the contract is voidable, ang issue natin kasi dyan is vitiation of consent. Ibig sabihin, the consent was obtained through fraud, undue influence, intimidation, fraud, etc. Okay, but in the case of minors, the Civil Code provides that the sale to a minor may be rescinded in case of lesion or in case of economic prejudice or economic disadvantage. Halimbawa, the child purchased an item for a price that is more than the reasonable price of the item, and the variance must be at least 1/4, okay, 1/4 or 25%. So pag nalugi siya ng by 25%, pwedeng i-rescind yung contract. Yan. So kung i-apply natin yung rules on obligations and contracts, the proper term is rescission or rescissible contract. But in the case in the law on sales, no, particularly under Article 1490 or 1491 of the Civil Code, if it's a sale by minors or purchased by minors, the sale is valid until annulled. Okay. Now, the more complicated part of relative incapacity would be with respect to certain persons who are related to the subject or the object of the sale. For example, you have husband and wife, agent and the property of the principal, the guardian with respect to the property of the ward, a government official with respect to the property of the state. Okay, so in these instances, they are not permitted to enter into a contract of sale. First, between husband and wife, they cannot buy and sell to one another because they are under a community, absolute community regime or a conjugal partnership of gains. And the reason provided by the law or by commentators is that by allowing them to buy and sell, actually it will just cause distortion of the absolute community of property. And at any rate, since they share everything what they have, there is no need to buy and sell to one another. What the wife owns, the father also owns. Okay. And the second reason is that the incapacity there or prohibition is there to protect creditors of either spouses. Okay, so for the protection of creditors din yun. Okay, now with respect to agents, guardians, trustees or administrators and executors of the estate, including, of course, government officials, with respect to properties belonging to the state. Ang reason kung bakit hindi nila pwedeng bilhin yun is because they are supposed to be the custodians and protectors of these goods or these properties. So if they are allowed to buy these properties, then that would violate the trust and confidence reposed in them. Because imagine this, kung ikaw ay agent and you have been tasked to sell the property of the principal, if you have an interest in that property, most probably would like to buy it at a price that's most advantageous or convenient to you. So, syempre, the lower, the better. Pero sa part naman ng principal, gusto niya mabenta yung property to a buyer who can pay the highest price. So, inconsistent ngayon yon. So, the principal wants to sell the property at a high price, an agent would want to buy it for himself at a low price. So nagkakaroon ng conflict of interest. Ganon din ang mangyayari pagka yung guardian bibilhin niya yung property ng ward, syempre iisipin niya yung sarili niya instead of the interest of the ward. At the same also goes to the administrator or executor of an estate who has been tasked to sell the properties of the estate. Now, of course, these relative or these situations where the parties suffer from relative incapacity can be waived or can be remedied in case of consent or permission of the party concerned. For example, the principal may give his consent to sell the property to the agent himself. The guardianship court may also give consent or approval to the proposed purchase by the guardian of the property of the ward. The settlement court may also approve of the request or the proposal of the executor or administrator to buy the property. Okay, one last group or one last class of people who are suffering from relative incapacity are judges, court officers, court employees, and lawyers. And their relative incapacity is with respect to properties that are subject to litigation. Okay, meron bang trust and confidence in the same way that guardians, agents, and executors have with respect to the properties which they are tasked to administer or to manage? Well, wala namang management as to properties that are subject to litigation. But the thing is, court officers, judges, including lawyers, must not be biased or must not be influenced by selfish or ulterior motives in the performance of their functions as such officers of the court. Rather, they should deal with the property as objectively as possible, because there will be a great effect on the outcome of the court case, or even in the discharge of their functions, if they have an eye on the property which is subject of litigation. Okay, now because the law says for as long as the property is subject of litigation, then the relative incapacity or prohibition ceases when the case has already terminated, because in that case the property is no longer subject of litigation. All right. Okay, matingnan natin kung sino mga nandito. Attorney, miss ka na namin, class mo, sir. Oh, hi Rajid, I miss you too. Ayan, pero okay lang yan. Natutuwa ako because you are already, I think, 3rd year or mag-4th year ka na. Ayan, that's good. Konti na lang. Ayan, magbabar ka na din, mag-abogado na. Ito si Mr. Rajid, who's watching now. He's one of my brightest students from University of the East. Accountant po siya, and in my subject, in partnership, I don't know if you were able to answer the question involving the one-person corporation, but I think when I discussed the one-person corporation, parang nagulat ka, sabi mo, ay, o nga pala, no, pwede pala yun. Pero I think you were hesitant or you were reluctant to agree to that idea kasi baka nga merong ang ethical repercussions yun. But anyway, of course, the viewers would not have any idea what I'm talking about, but just a hunch, no, or just a hint for you all. Now corporations can enter into partnerships, and if you want to limit or reduce the liability of a general partner in a partnership, you can have that general partner form, okay, a one person corporation, para ang liability lang niya, instead of his personal assets, ang liability lang will be limited to the properties of that one person corporation. Okay, anyway, hi Miss Elizabeth, she's watching from Kawayan City, Isabela. Ayan, medyo malayo na, as in physically, I mean in terms of distance, but you know, with the internet, walang malayo. Ayan, so welcome and thank you for watching. Okay, now let's continue. Alright, so let's talk about consent. So, you know, tandaan nyo lang yung basics ng obligon, no? As far as consent is concerned, sabi natin, consent is the meeting of the minds. It's the concurrence of the offer and the acceptance. Okay, so the offeror in a contract of sale can be the seller or the buyer. When it is the seller who makes the offer, then his offer must be with respect to the thing, the determined thing, as well as the price for which the thing is being sold. If the offer is from the buyer, then the offer must be with respect to a thing as well as the price for which the buyer is willing to buy the thing. Ayan. Now, the other party, meaning to say the offeree, must accept the offer unconditionally and must not change the offer. Otherwise, if he changes the offer, then that is not an acceptance but rather a counter offer, which must also be accepted by the original offeror. Okay, now aside from the thing and the price, if there are conditions or accidental stipulations, then these must also be agreed upon by the parties, okay, pursuant to the consensuality of contracts. Okay, so tulad na sabi, okay, na pagka-conditional sale yan, and if there are conditions to be agreed upon or to be fulfilled, then the same must also be accepted. If the manner of payment is by check, then dapat din that must also be accepted by the parties. Okay, so now let's talk about the subject matter or the object of the sale. So first, it must be determinate. A thing is determinate if it is identified, described, and segregated from its class. Okay, except or unless the thing is to be created from scratch, most of the things that are the subject of a sale come from a bigger class. For example, sabihin natin rice. So rice comes from a bulk of, or a bigger volume or a bigger class of rice. Also, if it's let's say a car, then a car may be or may look the same as other cars. So for the sale to be valid, the object must be determinate. So an object or the subject matter of the sale may be made determinate by, let's say, its size, its weight, its area if it's real property, serial number if it's a personal gadget, the model if it's other personal gadgets or goods, or even the brand name, no? So anything that will segregate it from its class will make that object determinate. Okay, if it's not determinate, then of course it does not satisfy the requirement of the law. Now it must be licit and within the commerce of man. So they are usually used interchangeably. You say it's licit if it's not illegal. If it's also when you say it, if it is you say it is within the commerce of man if it is subject to appropriation. So for example, medicines are licit objects, but narcotics are illicit objects because we have a law that makes narcotic drugs illegal. Now a parcel of land is within the commerce of man because it is subject or it is capable of private ownership. But then a public road is not within the commerce of man because it is not subject to private appropriation. So distinction must be made. You have to check the nature of the object, if that object can be the subject of a contract of sale. If it cannot be a valid subject of a contract of sale, then the sale is invalid for lack of a valid object. Okay, next thing to remember about the object of a contract of sale is the law on, or the rule on, nemo dat quod non habet, simply translated as you cannot give what you do not own, okay, or you cannot sell what you do not own. So a seller must be the owner of the thing, okay, so that he can transfer ownership. Although it relates more to the obligation or qualification of the parties, but it also goes into the object. So if, let's say, a person sells a property that does not belong to him, even though that object is determinate, and even if that object is licit and within the commerce of man, the sale is still invalid because the object is not something that the seller can transfer to the buyer. Okay, so even if all the requisites are present, the price has been paid, and yet, okay, at the end of the day, there is no valid object. It can be an imaginary object only because the seller could not transfer and deliver the thing. Okay, now regarding nemo dat quod non habet, remember the following points. The seller must have a right to transfer the ownership thereof. So even if he is the owner, but if his property is, or if his ownership is impaired by some agreement, no, for example, if it is a subject of a lease with the right of first refusal or an option to buy, then his right to transfer ownership will be impaired or subject to a prior right, okay, by another person. Now also, let's say the property is acquired under the Comprehensive Agrarian Reform Program, and so the farmer beneficiary who acquired that property is prohibited from alienating or selling the property within 10 years from the award. So kaya hindi rin niya pwedeng ibenta yon. So restricted ang right niya to transfer ownership. Okay, but take note that this requirement to transfer ownership must be present only at the time of delivery. So even if at the time of the sale, the seller was not in a position to transfer ownership, but if they had stipulated that delivery will be made at a later date, and at that time the seller would now be the owner of the property, then that would be a valid sale. It will still comply with the rule of nemo dat quod non habet. Okay? Now, what are the exceptions? Okay, so meron natin exceptions sa nemo dat quod non habet, which is that if the party stipulated a later delivery. Pero meron pa exception doon, exception to the exception, and this is when the seller, even though he stipulated a later date for delivery, is still prohibited from alienating it in the first place. For example, in the case of a farmer beneficiary who acquired the property under the Comprehensive Agrarian Reform Program, if the alienation was made within the prohibitive period, kahit na they stipulated that the delivery will be after the 10-year prohibitive period, that is still void. Okay, why? Because the effect of the sale happens at the time of the execution of the sale. Okay, so since the sale was made during the prohibitive period, so the sale is void. Okay, next, in case of an heir who sells a property belonging to his parents who are still alive, that would be a void sale because you cannot sell future inheritance. Ayan. So nasa batas yan, a person cannot sell future inheritance because for as long as his ascendant is still alive, his rights, an heir's rights to the properties of his ascendant are merely inchoate. Okay. Alright, now what about Article 1434 of the Civil Code? Now this is another exception to nemo dat quod non habet. According to Article 1434, when a person who is not the owner of a thing sells or alienates and delivers it, and later the seller or grantor acquires title thereto, okay, ibig sabihin the same seller, okay, after parting with the property, which at first instance should be considered void because of the rule on nemo dat quod non habet. Okay, but if that seller or grantor subsequently acquires title thereto, then such title passes to his buyer by operation of law. Okay, and that cures the defect of not complying with Nemo dat quo non habet at the time of the sale. So Article 1434 is illustrated in Castrillo versus Court of Appeals, decided in March 1964, where the seller, Isabel, was not yet the owner when she sold the property to the buyer, named Dimaranan. But the defect was cured when Isabel subsequently acquired title after the original owner, Crispina, sold the same property to Isabel. Ayan. So instead of the property being returned to Crispina, since binenta na rin ni Crispina kay Isabel yung property, so ano na siya, kumbaga ratified na yung contract, yung void, well, technically dapat talaga voidable yung contract, no? Because if it's a void contract, then it cannot be ratified. But you see, Article 1434 is an exception. So tandaan nyo lang tong Article 1434, no? And since it is an exception, it must be construed strictly against the person who is claiming the benefits of Article 1434. Okay, another thing to note about Article 1434 is that article, as I said, strictly construed yan. So Article 1434 does not apply when it is in conflict with the provisions of other laws. Thus, in Hermosillo versus Remuquillo, decided in January 2007, the Supreme Court did not apply Article 1434 when at the time of the sale of the property, the seller was prohibited by law to sell or convey the privilege to buy the land before it was awarded to him. Okay, so in Kuwait pa yung right niya, pero binenta na niya. So although later on he acquired title to the property through an award from the government, it did not cure the defect because again, meron kasi tayong prohibition against alienation of properties that are awarded, okay, by the state to qualified individuals. Okay, in Marcelo versus Marcos, decided in October 1961, the Supreme Court held that the subsequent acquisition by the mortgagor of title to the property through a free patent does not validate the mortgage because the Public Land Act prohibits the use of the land for the satisfaction of debts within 5 years from the issuance of the patent. Okay? Alright, anyway, so yan, yun yung mga instances na hindi natin i-apply yung Article 1434. Okay, now, some notes on the price. So this is the third element. So, a price must be certain. At yun nasabi dun sa Article 1458, no, the price must be certain in money or its equivalent. When you say it's certain in money, well, first, when you say it's certain, it must be definite, and the price must be fixed. So how is it fixed? Well, it is fixed by, number one, when it is agreed upon by the parties. Okay, so that's part of the negotiation process. So once it is agreed upon by the parties, then the price is fixed, it is certain. Next, when it is in reference to another thing certain. So when the parties cannot agree on the price, okay, so the alternative is to use another thing, another determinate thing as reference. For example, the subject of the sale is a sedan, a car, then they can agree that the price of this car will be the same price as another car of the same make, of the same brand, and of the same year, okay, or the same model year. So yun. Now, they can also use another thing, not a car, as a reference. For example, they can use a house, and although normally a house would be more valuable or expensive than a car, but if the car has sentimental value, then the added value there too is more than, quantifiable in money. So yun. So nasa kanila na yun, no, if they agree to use another thing certain as reference. Okay, now the third way to make the price definite or to ascertain the price is by leaving the fixing of the price to a third person, and here the parties must agree, okay, to accept the estimate of a third person. This usually happens in case of sale of property, forced sale of property, and an appraiser is engaged to fix the price. An example in point, a case in point would be expropriation. In expropriation, if the parties, meaning to say the expropriator, which is usually the state or a representative of the state, and the landowner cannot agree on the just compensation, then the trial court will appoint a commissioner, and this commissioner will now make his appraisal and will give the estimate to the court or to the parties if they can agree. Okay, now also related to the price is the manner of payment. So what is this manner of payment? Manner of payment is simply the way or the method by which the buyer will pay the price. Under your obligations and contracts, an obligation is pure unless otherwise agreed upon by the parties. And if it's a pure obligation, it is demandable at once. And also under your obligations and contracts, if the obligation involves the obligation to pay a sum in money, then that money should be paid in the legal currency. So, ano pa ba ang pwede stipulate ng mga parties kung andyan na nga, meron na nga palang provision ng batas? Well, we already said in our topic on obligations and contracts that the parties have the freedom to contract. They have the freedom to, or the autonomy to stipulate on on all matters involving the contract, including the payment of the price as applied in the law on sales. So, if they decide to stipulate on the manner of payment, then these two must be agreed upon by the parties. In fact, in the case of Toyota Show versus Court of Appeals, the Supreme Court said that failure to agree on the manner of payment results in the failure to agree on the price. Because price is not, I mean, of course, this is applicable only to conditional obligations or obligations with a period, but not to pure obligations. Because if the obligation is pure, we already have the civil code. We already have the civil code in its provisions regarding the payment or the performance of pure obligations. But if it's a conditional obligation, then the manner must be agreed upon. I mean, ano to, by cheque ba to or by cash? What's the frequency? Is it weekly? Is it monthly? Then this should be agreed upon by the parties. Now, the buyer must agree para at least he would know kung kaya niya. The seller must also agree para at least he would know when to expect the buyer to perform his obligation. Okay, next would be the distinction between failure of consideration and lack of consideration. Ano ba pinagkaiba nun? Parehas lang namang walang payment yun, di ba? Well, there's a difference. In failure of consideration, the parties have agreed on the price. Okay, so if it's 1 million pesos, then that 1 million pesos is binding on both the buyer and the seller. Failure means the buyer failed to pay the agreed price. So if it's 1 million, that means the buyer failed to pay the 1 million pesos. Lack of consideration, on the other hand, happens when the parties failed to agree on the price at all. Okay, so walang price. So the contract is, let's say, the sale of a Toyota Vios from A to B, and that's it. Okay, the thing may have been described, particularly described, but there is no price. So there is lack of consideration. So there is an absence of an element, so therefore the contract is void. Also, if the parties agreed on a price, but they were not bound by it, okay, they did not bind themselves to respect or to observe that price. In other words, simulated yung price na nasa kontrata, because as between them, it should be, or it is, a contract of donation or a deed of donation. So in that case, there is lack of consideration guised as, well, it's a sale, or it's a donation guised as disguised as a sale. So there is no consideration, there is lack of consideration, hence the contract is void. So what are the varying remedies? If it's failure of consideration, then the seller can sue for specific performance, or if the buyer fails to pay despite all chances given to him, then the seller can rescind the contract. Okay, these are the two remedies because the contract is already valid and binding. But in the case of a sale that has no consideration, or a sale that lacks consideration, the remedy is to declare the contract null and void. So nullity of the contract, because there is no valid contract to speak of due to the absence of one element, and that is the element of the price. Okay, what is inadequacy versus simulation of price? Now, remember that since in a contract of sale, the parties agree to both the object and the price, particularly with respect to the price can go up or can go lower, or can be higher or lower than the actual value of the thing. And it doesn't matter for as long as the parties agreed to that price. Okay, because the meeting of the minds is paramount than the actual value of the thing. So, the mere inadequacy of the price, meaning to say, kung ang presyo is mababa kesa do sa value ng property, that is not a ground to annul the contract. Okay? Because, again, the meeting of the minds prevails over the actual value of the thing. Now, it's a different thing, however, when it is gross inadequacy of the price. When you say gross inadequacy of the price is too low. Okay? Ito, kailangan meron kang condition doon. Okay? Gross inadequacy such that no reasonable person or prudent person would have bought or sold the property at that price, because it's either shocking to the conscience, or that the price is so inadequate as to reveal an intention to just give away the property. Yung bang nag-agree sila sa price pero sobrang baba ng price na para na lang binigay or dinonate na lang yung price. For example, the property is worth 10 million but it is only sold for 1,000 pesos. Okay? So ano yan? Parang ano lang, konsuelo lang. Parang okay, maraming salamat, token lang yung 1,000 pesos. Okay, so that's why gross inadequacy that is shocking to the conscience, or such that it will manifest an intention to just give away or to donate the property, will make the contract void. Okay, but if it's a mere inadequacy, for example, the price of the actual price is 1 million pero binenta ng how much? Let's say 500,000 pesos. Yes, it's inadequate, but it does not affect the validity of the price. Alright, now simulation of the price is the same as lack of consideration, because although they agreed in the contract that there is a price, but in reality they were not bound by it. That's a simulation of the price. Now question, if donation was really the intention, can the contract or can the instrument be reformed instead and thus convert that into a deed of donation? Okay, remember in our obligations and contracts lecture, reformation of instrument is a remedy, well, primarily to preserve or to save the contract instead of terminating it or canceling it. But my answer to that question, which is whether or not a deed of sale disguised as a deed of donation can be reformed and make it a deed of donation, well, the answer is no, because the intention must be clear in the contract itself, but because of mistake or fraud, the wordings or the phraseology of the contract failed to express that intention. In the case of a deed of donation disguised as a deed of sale, clearly there is a different intention. Doon sa deed of sale, dapat palang intention is to convey the property by onerous title. Pero kung donation palang intention, then hindi na yun mistake of the phraseology of the contract, but rather it is an intended mistake, if you will. No? Meron ba ganun? Yes, meron ganun. If it's an intended concealment of the parties, okay, to conceal the intention, which is to donate, then hindi yan makukure ng reformation. So, i-void mo talaga yung kontrata. Alright. So, now I'd like to talk about the right of first refusal. So, what is the right of first refusal? Okay, the right of first refusal is a right that is attached to a lease contract, giving the lessee the right to buy the property in case the lessor wants to sell the property. Okay, so the right has evolved, no? Has evolved, and quite interestingly, because nag-iba-iba ang interpretation, nag-iba-iba ang Supreme Court as far as its interpretation of the right of first refusal. So, but then let's first look at its evolution, no? So first, in Angyo Asuncion versus Court of Appeals, sabi ng Supreme Court, this right of first refusal is not binding because technically speaking, there is still no offer to sell the property. So kung wala pang offer, then wala namang nababiolate na offer. That offer can still be withdrawn before it is accepted. Okay, so yun ang sabi ng Supreme Court. So the seller can still sell it to another person because hindi pa nga naman in-offer kay ni seller. So hindi masyadong malakas yung effect ng right of first refusal. It was a toothless stipulation in the case of Angyo Asuncion. Okay, now in the case of Equatorial Realty versus Mayfair, iba naman ngayon ang interpretation. This time the Supreme Court considered it as a right in favor of a creditor. Okay, so bakit creditor? Well, because that stipulation gives rise to rights and obligations. Right in favor of the lessee and obligation on the part of the lessor. So kaya it is a demandable right, and so if the contract is, or if the property is sold to a third person without giving the lessee the prior right to purchase the property, then that sale to a third person is a sale in fraud of creditors. So kaya ang lessee can file an action poliana or an action to rescind the contract by the lessor and the third person. Okay, but then medyo tinemper ng Supreme Court yung masyadong strong terms na ginamit dito sa Equatorial Realty. So in the case of Rosencar and also dito sa Tanay Recreation Center, the Supreme Court said that the right to rescind the contract is limited by the possibility that the third person or the stranger who bought the property is an innocent purchaser for value. So kung innocent purchaser for value siya, then that contract cannot be rescinded because he is also, that third person is also protected by law. Okay, so what the lessee who has a right of first refusal can do is to seek damages against the lessor. Okay. Alright, now let's talk about the birth of the contract of sale. So there are 3 stages to a contract of sale. We have the negotiation stage, the perfection stage, and the consummation stage. So in the negotiation stage, there is the concurrence of the offer and the acceptance, and here no rights are still demandable because they are still negotiating. A contract arises only when there is a meeting of the minds. But what happens, or is there a remedy against a negotiating party who just withdraws arbitrarily or suddenly without any valid reason? Yung bang nag-uusap na kayo tapos last minute bigla siyang nag-withdraw at sabi niya, ay hindi na pala ako interesado. Tapos marirealize or malalaman mo na lang na meron palang nag-offer sa kanyang ibang tao. And the offer was very high. It was too good to resist. So in that case, depende, no? You have to check if there was in fact abuse of right, no? So you can file an action for damages against the other contracting or the other negotiating party under Articles 19, 20, and 21, which are of course the civil code provisions on the abuse of right. Okay, so remember, pagka negotiation stage pa, wala pang binding contract, so no right of action except when the failure of negotiation is due to bad faith. And here you can file an action for damages under Articles 19, 20, and 21 of the Civil Code. Now, perfection is the next stage. So after negotiation, if the terms have been agreed upon, nag-meet na yung offer and acceptance, then you now have a valid and binding contract. And all the obligations of the parties arise upon the perfection of the contract. including the obligation to deliver the property, the obligation to transfer ownership, and the obligation to pay the price. Now, hindi po kaliwaan ang contract of sale. If they have agreed upon the contract, then they are supposed to perform their obligations at the same time. Okay. Now, take note, however, of Article 1191 of the Civil Code, no, on rescission. If it's not provided under Article 1191, but in the interpretation of this article by the Supreme Court, sabi ng Supreme Court, you cannot rescind a contract due to non-performance of the other party if you yourself, okay, are not ready to perform your own obligation. Okay, so kung ikaw si seller, tapos hindi nagbabayad si buyer sa'yo, hindi mo pwedeng i-rescind ang contract using as ground yung failure or failure of the buyer to pay the contract price if in the first place you are also not willing and ready to deliver the property and transfer ownership. So kailangan when you go to court and avail of these remedies of rescission, including specific performance, you must be ready to perform your own obligation, particularly in a contract of sale kasi nga bilateral contract siya. Okay, now consummation or execution is that part where the parties execute their respective obligations. It can be a total performance or a partial performance. The point is when a buyer, of course, makes a down payment, then the contract is already partially executed. Okay, speaking of payment, nakalimutan ko lang, babalikan ko lang isang slide ha. Ayan, difference pala of earnest money and option money. Okay, so if it's an earnest money that is paid by the buyer, it is evidence of a perfected contract. Okay, so pag earnest money yung nasa resibo, ibig sabihin binding ng contract, and earnest money is a down payment. But if it is only an option money, then it means that the money is the consideration for the option to buy the property. In other words, binigyan lang yung buyer ng privilege to buy the property, and in exchange for that privilege, nagbayad siya ng option money. Well, in the vernacular or in the more common parlance, we call that reservation. Okay, so may reservation agreement as may reservation fee, but that's not the contract itself, and the reservation fee is not the contract price. So an option money or an option contract is not evidence of a perfected contract, but rather it should be the down payment, or in some cases the earnest money, that evidences a perfected contract of sale. Alright? Okay, nandyan pa ba kayo? Kamusta na kayo dyan? Hi sir, if Mary Duma incorporate as OPC, is the consent of her husband necessary? Okay, question ni Jermaine, hindi na po niya kailangan humingi ng permiso to form an OPC. Okay, but if he is putting conjugal properties as part of the OPC's assets, syempre kailangan ng consent ng nung husband niya. Okay. Alright, thank you. Hi everyone, welcome to my channel. Hi vlog, welcome to my guys. Hi guys, welcome to my vlog. Ayan. Okay. Alright. Inom mo tayong tubig. Medyo mahaba itong sales. Nakakailang slides pa lang tayo. Naka 13 but I have 32 slides. Medyo bibilisan ko lang. I'll just skim through some of the slides. Kasi meron pa tayong contract of lease. At saka there is no substitute for formal schooling, guys. If you are still in law school, okay, study very well, read your books, read the codal, read decisions of the Supreme Court, and please pay attention to your professors. Kahit na sitingin nyo boring yung subject, basta makinig lang kayo na ang gumawa ng excitement. Okay, nasa sa inyo na yung diskarte niyan, how to make the subject exciting for you. Alright, now in a contract of sale, meron ito yung tinatawag na diligence over the thing. Okay, and these are incidental rights and obligations. Remember, in your obligations and contracts, when the obligation involves the delivery of a thing, the obligor, meaning to say the person who has the obligation to deliver the thing, must exercise due diligence, okay, over the thing from the time of the execution of the contract up to the time of the delivery. So, the obligor in an obligation to deliver the object of the sale is of course the seller, because it's the seller who has the obligation to deliver. So, prior to delivery, the seller has to exercise due diligence in the care and custody of the thing. So, halimbawa, bumili ka ng let's say makeup, yan, mga lip tint, mga eyeshadows, ganyan, whatever, ganyan. And this will be delivered a week after the purchase, or because of the shipment, the turnaround time, madi-deliver siya sa'yo from 3 to 5 days. So it's the seller's obligation to exercise due diligence over the care of the thing until such time that the thing is received by you as the buyer. So if the things are received in poor condition, or if the things are deteriorated, or worse, lost prior to delivery, then the seller is liable. I know maraming magtatanong dyan ngayon na paano kung may kasalanan is the courier? Well, if the courier acts as the agent of the seller, because it's the seller who chose or engaged the courier, then the negligence of the courier, okay, is attributable to the seller, okay, because as agent, the principal is liable for all the acts, including the negligence of the agent. Okay, now if the thing is already delivered to the buyer, then his duty to exercise due diligence, the duty of the seller to exercise due diligence, is terminated, and all the risks with respect to that thing or property will now be in the hands of the buyer, or for the account of the buyer. Alright, now the buyer is also entitled to the fruits of the thing if the thing bears fruits. So what are these fruits? We have natural fruits, civil fruits, and industrial fruits. Natural fruits, mean to say, these are the fruits that are the product of the trees, the plants, and the animals in the property. Industrial fruits are fruits that are the product of some use of human talent, okay, in that property. So, for example, kung may factory dyan, or merong planta or anything whereby products are produced out of that property, then those fruits also belong to the buyer. Okay, now civil fruits on the other hand are the income or the profits or interest coming from the property. For example, if the property is subject of a lease, so yung mga rentals na yan will also belong to the buyer. Okay, but when will the buyer be entitled to these fruits? Well, the civil code provides that the buyer will be entitled to the fruits from the time of the perfection of the contract, but the parties can stipulate that the seller will appropriate the fruits until actual delivery. So they must agree. Okay, kasi kung wala namang ganong stipulation, then the seller who receives or takes the fruits must account for them in favor of the buyer. So kailangan ibigay niya dun sa buyer. Now, if those fruits were perishable and they had to be consumed, then at least the value therefore should be given to the buyer. Ayan. So those are the things provided for by, these are basic things that are provided by law, but the parties, as I've said, can stipulate, especially because sometimes we buy properties we don't need yet. So for example, merong available na property dyan, okay, like land, like real property, okay, may potential, but then hindi mo pa gagamitin, so you will allow the seller to stay. Sige, dyan ka muna, ganyan. So sabi nung seller, may mga fruits dito paano yan, yung mga puno, yung mga halaman, they may bear fruits, so what happens? So they can agree na, sige, sa'yo na lang muna, basta pagdating ng, let's say, 10 years, or maybe even less, like 5 years, then everything standing in that property or on that property should be delivered to me as well. Okay, so yun, pwede naman yun, because that's not contrary to law. In fact, that is consistent with the freedom to contract of the parties. Alright. Okay, thank you, June. Hello, I hope you're enjoying and you are learning. Ayan. Dahil naka-live stream naman ito, panoorin nyo lang to. I mean, nasa YouTube channel ko lang naman to. Panoorin nyo na panoorin. I know of someone who messaged me before. Sabi niya, sir, pinapanood ko siya na para siyang podcast. So like when she's doing something else, so tina-turn on lang niya. Kaso nga lang, when you're listening to my videos, you also have to turn on the YouTube app. Okay, hindi siya kasi siya parang Spotify. Pero sige, no? That gave me an idea. What if gawa kaya ako ng podcast on Spotify para you can just, listen to my lectures even, when you're doing something else, like when you're typing or when you're reading cases from the internet, so at least it can just play in the background. But if you're watching this from YouTube and you're just after of the audio, you cannot close the YouTube app, no? Because it requires to be played, no? The app has to be turned on. Alright, sige. Anyway, let's continue. Okay, loss. Okay, sa loss, isa lang talaga ang rule talaga dyan. Ito lang sasabihin ko. Res perit domino. The thing perishes with the owner. So, whoever is the owner at the time of the sale shall bear the risk of loss. So, if the thing was lost when the thing was still in the possession of the seller, in other words, the seller has not yet effected delivery, then the seller should bear the risk of loss. But if the thing has already been delivered and it has been transferred to the seller, to the buyer, then the buyer shall bear the risk of loss. Okay? Now, alam ko si De Leon, meron siyang ibang position diyan, no? Yung exception daw to the rule on res perit domino, ang Article 1163 and 1262 of the Civil Code. Huwag na nating guluhin ang sarili natin. Tandaan nyo na lang yun. Res perit domino. The thing perishes with the owner. Okay? If ownership has not yet transferred because the thing has not yet been delivered, then it should still be the seller who should bear the risk of loss. Kaya pwede kang mag-demand ng a replacement or maybe a refund. Okay? Kung ayaw mo na. Sabi mo, ayoko na. Ayan, nawala na yung original, mukhang malas ata yung item mo so refund mo na lang ako. Pwede, kasi nga, ownership was not yet transferred. Alright, now let's talk about performance of the contract. So, obligations of the vendor to transfer ownership of the thing, to deliver the thing, its fruits, accessories, and accessions. Okay, so source is Article 1164 and 1166, nasa obligations of contracts yan. Next, to warrant against eviction and against hidden defects. We'll talk more about implied warranties in a bit. Also, to take care of the thing pending delivery, and also to pay for the expenses of the contract. Okay, but this can be the subject of waiver or contrary stipulation. Okay, notice that although the law says it should be the buyer who should pay for the notarization of the contract and other costs, no, including taxes, ganyan. But they can agree na the buyer will assume all these expenses para malinis yung matatanggap ni seller. So if the seller wants to get 10 million out of the property, out of the sale of the property, but there are some expenses like notarization, taxes, documentary stamp taxes, etc., ganyan. Sasabihin ng seller niyan, hindi, ikaw nang bahala dyan, basta sa akin malinis 10 million. Okay? Now, if you are the buyer, of course, then you have to think about it. Sabihin mo na, well, I could resell this for a higher price and recoup or recover what I paid, no? Especially yung excess, no? Pero kung ayaw mo naman, parang sabi mo, medyo malaki naman masyado to, then you adjust. Sabihin mo, no, 9 million na lang sa'yo sa halip na 10 because yung sobra niyan, yan yung mga gagamitin ko for taxes as well as for registration. Ibig sabihin for transfer of registration. Alright, but again, sabi ko nga, talagang all these can be the subject of stipulation. Alright, obligations of the vendee. So, akala nyo lang, pay the price lang. No. Other than the payment of the price, the buyer is also bound to accept delivery. Ayan. So, balik muna tayo sa payment of the price. So, the price must be this, based on the terms which is subject to the stipulation of the parties. Otherwise, it shall be made at the time and place of the delivery of the thing. Now, when the price will owe interest, yan. Interestingly, if you will, pag-usapan naman natin to bukas, interest to be valid, interest on loans to be valid must be agreed upon in writing. At saka pag sinabi mo interest talaga, it's related to a contract of loan. Kasi nga, interest is the compensation for the use of another person's money. Okay? But did you know that in a contract of sale, the price can also earn interest? Okay? But is it a loan? Well, it's not a loan kasi una-una wala ka namang pinahiram dun sa buyer pag ikaw si seller. But as a seller, you are entitled to interest on the price in the following instances. Number one, if it is so stipulated that the price will earn interest according to the frequency or the term of the payment. So kung installment yan, then every month will entail some, let's say, 10%. Masyadong 10%. Baka sabihin nyo, that's usurious. Sabihin natin mga 0.5%. Ganyan. So, may stipulation. And also, if the thing was sold or delivered, if the thing sold or delivered produced fruits or income, and the buyer, tama ba? Sino ba ang mag-avail nito? Okay. So the price was not paid and the object is already with the buyer. Ayan. Okay. So the object has been delivered to the buyer, and it earned fruits or income. So since the price has not yet been paid, well, generally the buyer is already entitled to it, but because the price has not yet been paid, it will now result in the unjust enrichment of the buyer. I mean, hindi ka nagbabayad ng price, and yet you are already benefiting from the fruits and income of the property. So kaya kung magkano yung natanggap mo dyan, kung magkano yung na-benefit mo sa mga fruits and income of the property, I will add the value of that to the balance of the purchase price. Okay. And last is if the buyer is in default or in delay, and it shall be counted from the time of demand. Alright. So in effect, magiging debtor na si buyer in case of default. Now, what are the grounds for suspension of payment of the price? So, ang panlaban ngayon ng buyer, kung halimbawa, bakit hindi siya nagbabayad ng price? And of course, marami sa atin ganyan, no, na naghahanap ng excuse na paano ba? Parang kasi kung magbabayad pa rin ako, wala na akong leverage, wala na akong laban dun, wala na akong habol kasi binigay ko na sa kanya lahat. Well, if you are that kind of buyer who has a valid ground and you don't want to pay the price, then make sure that your grounds are any of the following. Number one, if the buyer is disturbed in the possession of the property or ownership of the property. By disturbed, of course, this must be legal disruption or legal disturbance. Kasi kung physical disturbance lang yan, like halimbawa a trespass, or hindi na problema ng seller yan, you being the occupant or possessor of the property has the right to repel the intrusion, and this is pursuant to the doctrine of self-help. Okay, so wag mo na iasa sa seller ang kaya mo namang gawin, okay, which is to repel the illegal trespass. And next is if the buyer has reasonable grounds to fear that such disturbance but there is a disturbance by a vindicatory action or a foreclosure of mortgage, and provided that this vindicatory action or foreclosure of mortgage is attributable to the seller. Okay, kung ikaw naman ang dahilan kung bakit ka dinemandan action publisyana or action vindicatoria, hindi nakasalanan ng seller yun. Okay, so you cannot suspend the payment of the purchase price. Alright. Okay, so next obligation is to accept delivery. Okay, so for the obligation of the seller to deliver to be completed, kasi nga yung delivery kasi it's a continuing process until it is accepted by the buyer. Okay, so kailangan i-accept ng buyer yun para matapos yung obligation ni seller to deliver. That's why in some purchases, about purchase ng kotse, purchase ng mga pinapadala by courier, meron kang pinipirmahan. So yung pinipirmahan mo, that is your delivery receipt. Okay, so okay na yan. Alright, so speaking of delivery, the delivery is, oh god, masyado pa mahaba to. Okay, akala ko kaya ko na isa oras to, hindi ko kaya to na isa oras. Okay, so delivery is the act of placing the thing in the possession and control of the buyer. Okay, take note of the conjunction and. Okay, so hindi pwede or. So kailangan placing the thing in the possession and control. So it's not enough that you place the thing in the physical possession of the buyer pero wala namang right si buyer to alienate it, to dispose it, etc. Kasi, ibig sabihin, hindi pa siya total or full owner. Possessor lang siya. Now, to be a total or full owner, dapat hindi lang possession ang may enjoy niya, but also he can sell it or sell, alienate, or even destroy it. Because those are the incidents of ownership. So, only in that kind of ownership or that kind of delivery will the buyer become the owner. Kasi it's possible that, okay, I am like in a contract to sell, okay, a developer will turn over the property to the buyer, but the buyer cannot sell, cannot mortgage, cannot get insurance over the property. So in effect, impaired or diminished yung rights niya over the property. So hindi siya full owner. So walang delivery doon as to, you know, bring about transfer of ownership. And the reason is obvious kasi hindi ka pa naman totally bayad. So kaya contract to sell ang in-execute at saka may reservation doon na hindi mo pwedeng ibenta sa iba. Okay, bakit merong pasalo, di ba? I'm sure iniisip nyo na yan. Bakit ganun pwede ang pasalo? So ibig sabihin pwede mong ibenta pala. No, that's something else. What the buyer in a contract to sell is selling is just his rights under the contract to sell, but not the property itself. So kung hindi ka nagbayad, pinasalo mo sa iba, so the assignee, sabihin the person who will buy your rights will have to continue the sale and continue the payment of the purchase price. Pag hindi naman siya nagbayad, nag-default siya, pwede talagang bawiin ng seller or developer. Alright, there are two types of delivery, physical or actual and constructive delivery. Physical or actual, of course, is the delivery of the thing by placing the thing in the possession and control of the buyer. Pag real property yan, hindi mo dinideliver yung property kasi sobrang laki niyan. Halimbawa, 1 hectare. Paano mo i-deliver yung 1 hectare sa isang tao na nakatira lang sa isang 20 square meter condo unit sa Makati? Diba? Hindi. So, gawin mo, yung tao na yun, ilagay mo dun sa 1 hectare property. So, that's delivery. Okay? Now, with respect to constructive delivery is that type of delivery which does not involve physical delivery, but, okay, by agreement of the parties, any act or some act is considered as, you know, transfer of ownership. So what are the different kinds of constructive delivery? Take note ha, kailangan may agreement yung mga parties na, okay, if I'm the buyer, I will accept the execution of a deed of absolute say, or I will accept the turnover of the keys instead. So yun, so kailangan may agreement. Otherwise, if the buyer insists on physical delivery, then constructive delivery is not effective. But under the Civil Code, these are the common types of constructive delivery. Execution of public instrument, traditio constitutum possessorium, traditio longa mano, traditio brevi mano, and what else? Symbolic delivery, placing of titles of ownership, as well as exercise by the vendee of his rights with the consent of the vendor. Hindi ko na-explain isa-isa yan ha, kasi masyado nang mahaba ito. Alright, anyway, so take note of the case of 1040 Realty versus Cruz, where the Supreme Court said that constructive delivery is merely presumptive. If the parties executed a public instrument or any other mode of constructive delivery, that, okay, is merely provisional. Okay? It has to be followed by some physical act of transferring the thing or delivery. Because if there is an impediment to physically deliver the thing, then that constructive delivery cannot prevent, okay, another person from having a better right to the property. So in the case of 1040 Realty, 1040 Realty purchased the property, and then it, okay, 1040 Realty and the seller executed a deed of absolute say. But the same seller sold the property to another person, and this second buyer took physical possession of the property. Of course, in good faith, without notice or without knowledge that the property has been sold to a different person. In this case, 1040 Realty. So, in good faith, yung second buyer. So, for so many years, okay, 1040 Realty did not even move to acquire or to take physical possession of the thing. So, in this case, tapos later on, dinimanda niya ngayon yung nakapwesto na doon, sabi na, I am the rightful owner. I have a better right because nauna na na-deliver sa akin ang property through the execution of a public instrument. Pero sabi ng Supreme Court, in this case, through the Ponente of Justice, later on Chief Justice Artemio Panganiban. That public instrument, while it is one of the recognized modes of constructive delivery, is merely presumptive. Okay, it's provisional. Okay, the fact is that someone else acquired a better right to it by physical delivery. At any rate, in-apply din kasi ng Supreme Court dito yung Article 1544 on double sales. So if you will remember Article 1544, meron tayong preference in case of double sales. Number one, in case of there is registration, then the first registration in good faith. If there is no registration, then the first possession in good faith. If there is no possession, then the oldest title in good faith. So sa situation ng 1040 Realty, you have 1040 Realty who had a deed of absolute sale, and you have the second buyer who had physical possession. None of them had registered the sale. So ibig sabihin, wala ni isa sa kanila may titulo sa property. Okay, so doon sa order of preference, ano sabi natin? Registration, followed by physical possession, followed by oldest title. So apparently, the second buyer had a better right kasi physical possession sa kanya. Yung deed of absolute sale, that's only a title. Oldest title means, okay, the muniment of title. In other words, the source of title, not the certificate of title. Okay, basa-basahin nyo, maganda tong case na to. Alright. Okay, double sale. So ayan, na-discuss ko na. Discuss ko na yung yung order of preference. Alright, so when rules under Article 1544 do not apply, so number one, when one sale is a sale, which for all intents and purposes will transfer ownership, and the other one is a contract to sell. And we said that in a contract to sell, there is a reservation of ownership, okay, until full payment of the purchase price. Also, while one deed of sale was registered ahead of the other, Article 1544 will not apply where the deed is found to be a forgery, okay, because a forged document or a forged instrument does not give rise to any legal right or obligation. And finally, Article 1544 does not apply if the property is not registered. Okay, so yan. So kung hindi naman siya registered, kumbaga unregistered land, under Article 3144 or something, basta anyway, check nyo na lang yan sa LTD na subject ninyo, ha, because there is also a database of unregistered lands, those that do not fall under PD 1529 or the public, as well as the older Public Land Act, because they were not placed under the torrent system, they are still covered, or they still have a method of recording transactions involving these unregistered lands. So I think it's Republic Act 3144. Anyway, check nyo na lang yun. Alright, so failure of the contract, in other words, breach of contract. So what are the remedies of the aggrieved party in a contract of sale in case the other party fails to perform his obligations? At eto na yung more mas concern ng, mas practical ang relevance ng ng part na to, kasi doon tayo sa mga types of sale or dito kasi karamihan sa atin, we just enter into a contract of sale always thinking that, okay, I'm going to buy this property, I'm going to enjoy this property if I'm the buyer. Pag ikaw naman si seller, isipin mo lang, okay, I'm going to sell this property and earn millions out of this sale. Okay, now what if that intention or ambition does not materialize? So anong remedies mo? Iyakan na lang? Siyempre hindi. The law provides for two remedies: specific performance and rescission. Okay, specific performance, of course, is the preferred, well, it's the priority. You have to allow the other party to comply with his obligations under the contract. Pag hindi pa rin pwede, then you can avail of rescission. But the remedies of rescission will vary depending on the type of property. So if it's a sale of real property, take note of the type of sale. If it's an absolute sale, then apply Article 1191 and 1592 of the Civil Code, which simply gives, okay, the buyer a grace period, okay, a right of preemption. In other words, pwede pa niyang bayaran yung utang niya for as long as no extrajudicial or judicial demand has been served upon him. So pag ikaw ang buyer, ang due mo is, let's say, March 1, okay, March 1. So ano na ngayon? March 20. Ayan. So pwede ka pa rin magbayad, no? Magbayad ka for as long as hindi ka pa dinidemanda sa court. But if you have been demanded, or you have been sued in court, then wala na yung right of preemption mo na demanda ka ni. Okay? But if it's a sale of real property on installment and covered by the Maceda Law or Republic Act 6552, then nandun yung mga remedies. Okay, so I hope you are very familiar with RA 6552 kasi favorite source of questions yan sa bar at saka syempre sa law school. Okay, if I would be your professor, dun sa mga naging estudyante ko na alam nila yan na favorite ko ang RA 6552. Okay, kasi nga well, aside from it's super rich with possible questions, every lawyer should know RA 6552 because we have so many countrymen who buy properties, real properties on installment. So dapat we should know the law so that we can give the appropriate advice. Okay, so apply RA 6552 if the sale of the real property is on installment or a contract or conditional sale. Okay, in case of personal property, however, apply Article 1593. Okay, so again, it gives the right of refund. Okay, now if the property is, or the personal property is sold on installment, meron din tayong special law dyan. Pero hindi naman siya special law kasi part pa rin siya ng civil code, and that special law is Article 1484 na ang tawag natin ay the recto law. Okay, so dun naman ang sinasabi lang dun is that alternative ang remedies. So the first the order of remedies is as follows. So first is specific performance. Now the seller may choose to cancel the contract if the buyer has failed to pay 3 or more, okay, or 2 or more. Ayan. 3 or more installments, or the buyer may, or the seller may foreclose the chattel mortgage constituted over the property subject of the sale, and all these remedies are alternative. So if the seller has availed of specific performance, hindi na niya pwede avail yung dalawa. Pagka inavail naman niya yung foreclosure of the chattel mortgage, let's say for example a car, it's a personal property sold on installment, so pasok sa Article 1484. Pag hinabol ng dealership or ng bangko or financing institution yung kotse, yung chattel mortgage, then hindi na niya pwedeng kasuhan yung buyer for the balance of the purchase price kasi that would fall under specific performance. So in effect, the seller would be availing two remedies under the same article 1484 na ipinagbabawal. Okay, alternative lang siya. Sabihin, pumili ka lang ng isa. Okay, you can't have your cake and eat it too. Okay, huwag ka masyadong ambisyosa. Okay, next, action for damages, of course, is available provided that the failure to pay or the failure of the seller to deliver or transfer the property is attended by fraud, bad faith, and negligence, malice. Yan. So, kasi damages kasi is not automatic. Yan. Because, it's supposed to be a penalty. It's supposed to be an added sanction upon the other party, but then to be awarded, these damages must be justified. Okay, not all breach of an obligation will entitle the aggrieved party an award of damages. Okay, warranties. There are two types of warranties: express warranty and implied warranties. Okay, so implied warranties are those that are provided by law, by the nature of the contract, and the purpose of implied warranties is to put the parties on equal footing. Why? Because the seller has full control over the property. As far as the title is concerned, siya lang nakakaalam. Siya ba talaga owner? Kahit na gaanong research pa gawin ng buyer, no? Hindi niya talaga malalaman lahat, no? Not everything about the seller's title will be revealed. You can go to the Register of Deeds, you can check, okay? Mag-tracing ka and all that. Okay? You can examine the title, back and forth, okay, front and back. But there can be things that will be missed by the buyer. So ang sabi ng batas, the seller, for the protection of the buyer, must guarantee that he is the owner of the property and that he has the authority or the right to transfer title to the buyer. Okay? Now, what else? In case of the manufacture or the production of the thing, again, the buyer has no idea how it was made, how it was manufactured, okay, or as to its quality. The thing can be inspected, but then what if meron defect dun sa manufacture ng thing? So that's why the court imposed also the implied warranty against hidden defects. This is to make sure that the seller will not sell substandard or defective items for which the buyer had no control of. Okay? So for example, bibili ka ng bahay sa isang subdivision, hindi mo naman monitor yung paggawa ng bahay. Paano kung may butas yung bubong, or paano kung the walls are not stable enough, ganyan. Kasi wala ka naman doon, because you're not allowed to monitor or oversee the construction of the house. Most of the time, you just get to inspect the property when it's already 90% completed. So wala na, nakatayo na talaga siya. But then thankfully, we have the implied warranty against hidden defects. So yeah, so to equalize, okay, to level the playing field, that's the purpose of these implied warranties. Okay, express warranties are of course those that are written or that are agreed upon by the parties. Usually you will see that in the warranty cards. Okay. Alright, extinguishment of the sale. The sale can be extinguished using the other modes or the other methods of extinguishing a sale. So you have loss of the thing. Basta yung mga common modes of extinguishment of an object or of a contract under your loan obligations and contracts. Now, in addition to that, we have conventional redemption and legal redemption. Well, both conventional and legal redemption are actually resolutory conditions. So, sinasabi lang na kaya siya extinguishment of the sale because the sale that was previously and validly entered into will be terminated because the thing will revert, okay, to the previous owner. Okay, so conventional redemption is also called pacto de retro sale or sale with right of repurchase because the seller reserves the right to buy back the property. Conventional redemption or legal redemption, on the other hand, is the type of redemption whereby a third person who is a stranger to the sale, okay, may buy back or get back the property because of some legal policy or because of some policy of the law. For example, legal redemption of co-owners. So as a rule, a co-owned property should remain within the co-ownership. So if one of the co-owners will sell his portion or his inchoate portion or his undivided portion in the co-ownership to a stranger, then the other co-owners have the right to redeem that share, okay, by paying the third person or the stranger and and getting back the share of the previous co-owner. Now also there is legal redemption by adjacent owners of rural lands as well as urban lands, because the idea is that if you are the adjacent owner or the neighboring owner, you would be in a better position to develop the property, but to allow a stranger to come in, that may just change the ecosystem, if you will, of the neighborhood, no? Because what if itong nakabili magtatayo ng condominium dyan? Okay, of course wala tayong binabanggit na real estate developer, yung bang pag may nakitang bakanteng lupa tatayuan agad ng subdivision or ng condominium unit. Wala akong binabanggit. Pero yeah, you get the point. So at least if you are already the neighboring owner, and let's say you are an agricultural land owner, at least if that's an agricultural land, then you would be in a better position to continue, okay, the nature of that property and keep it as it is. Okay, for urban lands naman ganun din, no? If you're a neighboring owner, then you would be in a better position to develop the same, okay, in accordance with the zoning of that property, okay, or of that area. All right, so okay, madaming cases to. Okay. All right, sige. Because I still need to discuss lease, so I'm going to flash, okay, these cases right on your screen. So if you can, just take a screenshot, or if you like, you can just rewatch this live and take note of these selected Supreme Court decisions. Anyway, the outline or the gist of that decision, okay, is there. So these are the selected decisions that are relevant to our discussion, to our lecture today. Ayan. So go. I'm going to count 5. Tapos I will change the slides. Dahil meron pa tayong list at naubusan ako ng boses. Okay. Alright. Next. 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 And next. All right. Okay, so that ends my lecture on sales. Pero wait lang, tingnan natin baka meron tayong mga commenters dito. You made sales and leases easier to understand. Thank you, Ma'am Rose. Okay. The best civil law reviewer yan. Ito talaga si Jude, talaga sip-sip talaga to. Hello sir, merienda time na muna sir. Kayo lang ata may merienda. Pahingin naman ng merienda dyan. Okay. Thank you very much, Miss Rivera. Yes, this is my passion. Okay, so kaya okay lang yan. I love doing what I do. So I'm happy to be able to share this to you. Okay, so yan po ang ating lecture on sales. Give me a minute, okay, to transform, to shift to our lecture on lease. Okay, guys. Hi guys, I'm back. So yan, nakapag-transform na tayo. So naka-green na ulit ako ngayon. Ayan. So kaya naka-red tayo, so ngayon naka-green naman. Okay, so we'll now discuss the law on lease. But before I proceed, I'd like to say hi to Miss Flor Alvarado. Thank you for the appreciation. And by the way, maybe you can comment where you're from, anong school, or where you're watching this from. So thank you for staying put. So we have one last lecture for today. That was bukas ulit, no? I will continue tomorrow. All right. So let's start. Okay. So what is the law on lease? So we'll start with the definition. The law on lease. Okay. What is the lease of things? I hope you can read the text, no? Medyo widescreen yun na lang. So, well, there are two types of lease, no? You have lease of services and lease of things. And in a contract of lease, of course, the main feature is just the temporary enjoyment or use of the thing, or the use or enjoyment of the services. There is no transfer of ownership, unlike in the case of a contract of sale. So, in the lease of things, one of the parties binds himself to give to another the enjoyment of a thing for a price certain, which we also call the rent, and for a period which may be definite or indefinite. But a contract of lease cannot last for a period longer than 99 years. But that's only for the first lease. So technically, they can enter into several leases, no, because there is no maximum number of lease contracts. The same parties can enter the same contract of lease for periods of 99 years maximum each. So 99 plus 99 plus 99 plus 99. So pwede perpetual lease talaga siya, no? Okay. So note that in a lease of things or lease of property, the lessor transfers merely the temporary use and enjoyment of the thing leased. There is no transfer of ownership. The buyer or the lessee also does not become the buyer or the owner of the property. Now, the lessor's right to use the thing is impaired, and the lessee now has a better right to the possession of the property. So, if the lessor retains the thing unreasonably longer than what is, of course, required by the contract, then the lessee can eject or can evict the lessor from the property. Remember, ejectment or eviction under Rule 70 of the Rules of Court deals only with the question of possession and not ownership. So even if you are the owner of the property but you have given the enjoyment of the thing to another person, you can be evicted, okay, if you have already lost the right to possess the property, pursuant to that contract, of course. Now, being a consensual contract, the contract of lease is perfected by mere consent. Okay, so it is not perfected by the delivery of the thing. There is no need to deliver the thing before the contract of lease is effected. So even if the thing is not yet delivered, the lessee may already be required to pay rent. Okay, for example, in the case of a new mall, for example, and the mall owner leases out spaces, commercial spaces in that mall, the spaces will of course be reserved already for the use of the lessee. So in exchange for that, the lessee has to start paying the rent. Now, of course, the parties may stipulate that the rent should start only after the turnover of the property. Pero kung walang ganong stipulation, well, under the law, the lessee should already start paying the rentals because, again, the obligations of the parties arise from the perfection of the contract. And a contract of lease being a consensual contract, it is perfected by mere meeting of the minds or agreement of the parties. Okay, so what is a lease of work or service? Ito na yung, for example, when you hire the services of an architect, an interior designer, a painter, a singer, etc. Okay, so that's a lease of services. You hire the services, but you do not become the owner of the services or the talent or even the person himself, no, because that's not within the commerce of man. But what you can be the owner of would be the output or the product of the services, in which case it is called a contract for a piece of work. Okay, now what is the difference between contract of lease and a contract of employment, as well as a contract of lease and a contract of agency. Well, in a contract of lease versus contract of employment, there is no employer-employee relationship in a contract of lease, and the control of the lessee of the services, I mean to say the customer, would only be with respect to the result rather than the means of attaining the result. In the case of an employer-employee relationship, the employer has control not just over the result but also over the means of attaining the result. Now, in a contract of lease versus contract of agency, the lessor of services does not represent the lessee or the customer. Okay? While in a contract of agency, the agent represents the principal. So any act done by the agent, of course, binds the principal. Alright. Okay. Yan. Sinagot ko na. Alright. Now, what are the important considerations in a lease of rural and urban lands? Okay, so let's now go to lease of properties. So the persons who are disqualified to buy properties, remember, those who are covered under Articles 1490 and 1491, yung husband and wife, those agents, guardians, public officials, they are also prohibited from leasing or renting the property, okay, subject or owned by the other party. So an agent cannot lease the property owned by the principal. A guardian cannot also rent the property owned by the ward. Of course, the exception is when the court approves the request or the intention to lease the property. Okay, now lease of real property to be binding on third persons must be registered. So how do you register a lease? Well, simply by submitting a copy of the lease contract to the Register of Deeds, assuming that the property is titled. So if it is titled, the contract of lease will simply be annotated at the back of the certificate of title. Now, if you watch my lecture on land titles and deeds with the VLC or the Villasis Law Center, I also discussed there the different involuntary dealings with respect to real properties, including lease contract. So a lease can be annotated on the property or on the title of the property, and it can only be discharged by an affidavit by the lessee or executed by the lessee stating that the lease contract has already expired or has already terminated. And that's the only way for the lease contract or the annotation with respect to the lease contract to be removed from the certificate of title. Otherwise, if that annotation remains on the title, then third persons are bound to respect it, and their dealings with that real property will be affected by the result of that lease contract. So if you are buying, or if you are interested to buy a real property and it is subject to a lease contract, kasi may annotation doon, better check if the lease contract still exists. Otherwise, pag hindi mo siya chinek, then you are bound to respect the lessee in possession of that property. Okay. Next, the lessee may sublease the property, and this right to sublease, of course, is granted, but it can also be restricted by stipulation of the parties. So, if there is no restriction, then the lessee can also sublease that property. Imagine, let's say, you rent a house, and you decide to rent the rooms in that house, okay, for bed spacers. That's valid, okay, because sublease is allowed. But if the contract states that you cannot sublease, then bawal yung magpaparent ka ng kwarto sa bahay na inuupahan mo. Okay, now the warranty against hidden defects in sales also applies in a contract of lease of property. So just like what I said earlier in our lecture on sales, to level the playing field, because the buyer has no participation or has no notice of the construction of the house or the manufacture of the goods. So ganun din pagka lessee, he has no participation, or he is not privy to the actual quality of the property, then therefore he is entitled to be protected by the warranty against hidden defects. By the way, the warranty against hidden defects is simply a guarantee that the property is of good quality, and should the object or the property be defective, he has two remedies: action quanti minoris or action redhibitoria. Okay. Action quanti minoris is an action to reduce the price because of the defect, or meanwhile an action redhibitoria is an action to rescind the contract because of the defect. Okay, so action quanti minoris, like in the case of a lease, may happen when, for example, because of the defect, kailangan gumastos nung lessee. Okay, so gagastos siya, so ibabawas niya ngayon yung ginastos niya doon sa pagpapa-repair. Also, kung ayaw naman niyang i-repair yun, but he feels that this property is not worth this amount of rent because of the defect, then pwede rin niyang bawasan yung rent. But of course, if the lessor disputes that, then they have to go to court, because hindi naman pwedeng arbitrarily si lessee babawasan niya yung renta niya. Okay, in case of conflict or dispute, it's best that there be judicial intervention. Okay, next, yung redhibitoria naman, that's only proper, or that is available when the lessee or the buyer, in case of a contract of sale, would not have bought or would not have leased the property, as the case may be, had he known of the defect in the property. Ayan. So it's really a question of intention. Okay. Alright, now what are the obligations of the lessor and lessee? Okay, so mas marami obligations na lessee, but looking at the list, of course, mas marami, but basically all these obligations are significant, and they have of equal weight, because in contract, following mutuality of the contract, okay, and the commutativeness of the contract, the obligations of the lessor should be considered equal in weight and value as the obligations of the lessee. Okay, so on the part of the lessor, he has the obligation to deliver the thing in the condition for which it was intended. Okay, so if the house is intended to be a residential place, okay, for the lessee and his family, then the thing should be delivered in such a condition that it is ideal for residential purposes. Now, if it is also intended to be used as a commercial establishment or for the operation of a business, then dapat it should be delivered in such a condition. So, kung halimbawa kailangan ng parking space at sinabi ngayon ng lessee yun, so dapat walang mga obstructions sa labas ng unit or sa labas ng building. Kasi nga gagamitin nga siya as a commercial establishment. Okay. Now, the next obligation is to make all necessary repairs of the thing. So what are these necessary repairs? These necessary repairs are repairs to maintain the property in its usable state. The purpose of these repairs is only to meet the wear and tear of the property. So, halimbawa, if it's a house or if it's a condo unit, so yung tubig, kuryente, ganyan. So those are for the account of the lessor. So the lessor has to meet or has to spend for these necessary repairs. Pero kung halimbawa ang gustong mangyari ng lessee is paggawa ng second floor yung bahay, that's not a necessary repair anymore. Okay, that's a useful improvement, no? That's an ornamental expense or repair, if you will, no? So that's not a problem of the lessor anymore. Okay, next is to maintain the lessee in the peaceful and adequate enjoyment of the property for the entire duration of the lease. So what is this peaceful enjoyment? Now, here is where the controversy arises. No? Is it simply physical enjoyment, peaceful physical enjoyment, or is it legal peaceful enjoyment? Well, the Supreme Court has ruled that this obligation refers only to the legal peaceful or peaceful legal enjoyment. So, in other words, the lessor guarantees to the lessee that no person shall claim a better right to the property, or that as the lessor, he will shield or protect the lessee from any vindicatory action or any legal disturbance. Okay. So, if it is physical enjoyment that we are talking about, for example, in case of a trespasser, that's no longer the problem of the lessor. The lessee, who is in possession of the property has the duty to, preserve the property and repel such intrusions or trespass into the property. Again, following the doctrine of self-help. Alright, now let's talk about obligations of the lessee. So first is to pay rent. Okay, so that's number one. Because that's the cause of the lessor for entering into a contract of lease. Kaya nga siya nagpaupa or kaya niya pinaupa yung properties because he wants to earn income from that contract. So otherwise, kung gusto na niya ipahiram paggamit sa iba, then that would be a contract of comodatum. Okay, because a comodatum is, of course, essentially gratuitous. Pinahiram mo lang. Para ka nagpahiram lang ng libro na walang bayad. Okay, so, but if it's a contract of lease, syempre, the lessor has the expectation that he will be paid rent. So that's the number one obligation of the lessee. Next is that the lessee should use the thing as a diligent father of a family, devoting it for the use for which it was intended. Okay, so hindi pwedeng sirain niya yung property, no? That's why a lot of people hesitate from or are reluctant to lease out their property. Lagi iniisip, naku, pag pina-rent ko yan, naku, kawawa ang bahay. Diba? Bababuyin lang yung bahay na yan. Kaya maliban sa kung ano ng mga kababuyang ginagawa nila sa bahay na yan. Kaya, diba? So, kaya ayaw nilang ipa-rent yan. So, that's quite sad because it clearly reflects that some lessees are not mindful of their obligation, which is the obligation to use the thing leased with the diligence of a good father of a family and also to devote it for the purpose for which it was intended. At any rate, if you are the lessor tapos binaboy nga yung bahay mo, you can actually evict the lessee for failure or for breaching his obligation, okay, to exercise due diligence and to use the property for the intended use. Okay, next is to pay for the expenses of the deed of lease. Okay, alam nyo, pansinin nyo, ang legislature hindi talaga consistent, no? Masyado tayong ginugulo talaga, kaya tuloy nahihirapan tayo mag-memorize. Sa sale, it's the seller who bears the expenses of the sale. Kumbaga, yung notarization, ganyan, ang seller. Pero pagdating sa lease, it's the lessee naman ang magbabayad ng expenses for the lease as well as its registration, no, if it is required. So, kakaiba, no? Kaya, yan, pinapahirapan tayo. Well, I think that's the challenge. Otherwise, if it were that easy, then everyone could be a lawyer now, di ba? So, yeah. But then, why not? Di ba? Mas maganda nga yung lahat abogado kesa lahat nag-aabogado. Alright, anyway. Next, to notify the lessor in case of usurpation or untoward acts. Okay. Now, of course, you have to qualify this. Untoward or usurpation or untoward act should be legal in nature. So, for example, merong claimant who claims, hindi lang intruder, hindi lang trespasser, kundi claimant talaga siya ng property. Like, sasabihin niya, well, I bought this property and all that. Ayan. Siyempre, pag ikaw yung lessee, hindi ka makakasagot ng maayos doon kasi hindi mo naman siya kilala, hindi mo alam yung sinasabi niyang transaction before you came into the property. So, you have to report that to the lessor because it is also, aside from the lessor should be informed of that there is some threat to his right or to his ownership over the property, it would also be the obligation of the lessor to protect the lessee from such usurpation or untoward acts, following the lessor's obligation to keep the lessee in the peaceful legal enjoyment of the property. Okay, next, to notify the lessor of the need for repairs. Okay, so these repairs are either necessary or useful repairs. Pero pag sinabi niyang necessary repairs, then of course the seller will spend for that. Okay, pero pag useful repairs, hindi seller, the lessor should pay for that. But pag useful repairs, the lessor will not pay for that, but he should still give his consent because that could result in the alteration of the property. And a lessee generally has no right to alter the property. He can only use it and return it in the same condition that it was received. Okay, if there is some alteration, then of course kailangan malaman niya ng lessor, because we have the rules, we have a different rule kasi maya pag-usapan natin yung rule on improvements introduced by the lessee to the property. Okay, next is to return the property leased upon termination of the lease. Okay. All right, what is the term of a lease if no period has been agreed upon? Okay. Now, if the contract does not provide for the lease period, then the period can be based on the amount of rent. So if the rent can be quantified based on a daily rate, weekly rate, monthly rate, or yearly rate, then madali na lang malaman kung ano yung period ng lease that was agreed upon by the parties. For example, if the rent is 1,000 pesos per day, and if the lessee remained in the property for at least 5 days, tapos nagbayad siya ng, let's say, 10,000 pesos, then that means the term of the lease is for 10 days. Ganyan. Okay, let's say the rent is 30,000 monthly. Okay, now nagbayad siya ng nagbayad siya 90,000 pesos. Okay, so that means presumably the lease is good for 3 months. Of course, syempre wala pa dito yung 2 months deposit, 1 month in advance, no? So let's just base it on the principal rental rate. Okay, so there you go. Now, may a lessee lawfully suspend payment of rent, similar to a buyer who has the right to suspend the payment of the price? Well, the answer is yes. First, in case the lessor fails to make the necessary repairs, or second, when the lessor fails to keep the lessee in the peaceful legal enjoyment of the property. Alright. So kapag yan yung mga reasons, then pwedeng hindi magbayad si lessee. Okay? But of course, it doesn't mean hindi na talaga siya magbabayad, because we know of some instances when hindi nagbayad noong una dahil meron siyang dahilan. Like, halimbawa, may mga dapat ayusin dito, hindi mo inaayos, hindi kita babayaran ngayon. Nung inayos na, nung sumunod na buwan, hindi na nagbayad, na nasanay na hindi na nagbayad, so hindi na talaga siya nagbabayad. So in that case, the suspension of payment is no longer justified. So he will now be at risk of being ejected from the property for non-payment of the rent. Okay? Pero kung meron namang basis, hindi pwedeng i-evict ng lessor yung lessee for non-payment of the rent, because the non-payment of the rent is justified. Alright, what are the grounds for rescinding the lease? Actually, marami meron pang grounds for rescinding the lease, meron ding grounds for ejecting the lease. Pero pare-parehas lang lahat 'yan. But the thing with rescission is that rescission is more of based on contract. So, halimbawa, if the lessor should not comply with the obligations, ganyan. So, it's the opposite kasi, 'di ba? Rescission is the counterpart of specific performance. So basically, the ground arises out of the terms and conditions of the contract. Ejectment naman, on the other hand, refers to that remedy which is made, or which is caused by an unfitness of the lessee, or the breach of some obligations under the contract, etc. Pero mas wider ang scope ng ejectment kaysa sa rescission. Okay, but at any rate, if you want to file an action for ejectment, you can also use the grounds for rescission, because the effect of rescission is that the lessee loses the rightful, or the right to possess the property. So basically, those are the grounds. So pa-check na lang yan. Okay. Alright, now for ejectment naman, so yan na, the period of the contract has been agreed upon, hence the lessee has already forfeited his right to possess the property. Also, if there is no payment of rent, he also forfeits his right to remain in the property. Ayan, okay. Now, by the way, pagka-ejectment or eviction pinag-uusapan, there are two remedies or actions under Rule 70 of the Rules of Court. Yung sa contract of lease, ang applicable doon is unlawful detainer. Okay? Wag forcible entry. Okay? Pag nag-forcible entry kayo, well, depende kay judge. No? Si judge, baka sabihin niya, anak, i-correct mo naman yung nilagay mong pangalan, yung pleading mo, nung complaint mo. Bakit mo naman nilagay dyan complaint for forcible entry? Ang basihan mo, contract of lease. Sige na, i-correction tape mo, palitan mo na lang. Okay. Mabait yung judge pag ganon, di ba? Kasi anyway. What is important is the intent. Okay? But hold your horses. Meron pa ako explanation doon. Now, but if it is a strict judge, pwede niya i-dismiss yan. Bakit? Kasi pag forcible entry, sabihin yan 1 year from the entry, di ba? From the unlawful entry. Yun ang prescriptive period ng forcible entry. Pero kapag unlawful detainer yan, it's 1 year from the time of from the last demand. So baka hindi mo na-meet ngayon yung 1 year period na yon, hindi mo na-recon ng tama. So kaya pwedeng i-dismiss ngayon yan ng court kasi nga mali yung remedy na ginamit mo. Alright. Okay. Now note also some grounds for rescinding the contract or ejecting a renter under the Rent Control Act. But the Rent Control Act is really applicable to residential houses, units, apartments, etc. Ang unique lang talaga doon is mas kino-consider yung lessor sa Rent Control Act. Why? Because the intent of the Rent Control Act is to put in check the prerogatives of the lessor. So kaya hindi siya pwedeng magtaas ng rent by I think 10% every year. So hindi pwedeng ganun. Pero nakalagay doon na the lessor may terminate the lease in case he has a need for the room or for the apartment. Next, second is when there is a relative, na uuwi at kailangan tumira doon, a member of the family na kailangan tumira doon. Imagine that that relative is already a stranger to the contract, and yet that can be a ground to terminate the contract. Nandun sa batas yun. So kaya you also have to consider the ground stated under the Rent Control Act of 2009. Alright, now this one is a very controversial right, no? And this is what we call the extrajudicial repossession of the premises. Ang tanong dyan ay, pag hindi ka nagbayad ng renta mo, pwede bang ipadlock ng landlord mo o ng lessor yung unit mo? At first glance or at first hearing of that act on the part of the lessor, maisip mo, hindi pwede, dapat pumunta muna siya ng court. No one can put the law in his own hands. He has to go to court. Even the most well-meaning person goes to court in order to obtain a court order. But then, this is a different case altogether, and this is what we call a stipulation for the extrajudicial repossession of the property. And in the case of Viray versus Intermediate Appellate Court, sabi ng Supreme Court, walang bawal doon, walang masama doon. But then you have to, read that decision in the proper context. First is that it was stipulated in the contract. It was stipulated in the contract, hence the lessee was aware that there is a possibility that the lessor could padlock the unit pag hindi siya nagbayad. Kung walang stipulation, syempre hindi pwede i-padlock yun ng landlord. He has to go through the process either by first sending the lessee a demand letter, second by going to the barangay, and then asking for the intervention of the barangay by calling the lessee to a conference. Pag hindi pa rin successful yun, then the lessor can go to court and file an action for ejectment or unlawful detainer. Now, but if there is a stipulation, then that stipulation is valid and binding pursuant to the freedom to contract of the parties. And according to the Supreme Court, this is similar or like a resolutory condition. So it's like when it happens, then it happens. So pag hindi ka nagbayad, then what will happen is that I will padlock the premises. Agreed? Sabi ng lessee, okay, agreed. So yun. So hindi siya pwedeng magreklamo. Alright, so wag na kayong magugulat kung merong mga units na pinapadlock or yung bang inilalabas na lang yung gamit. Pero malamang hindi na ilalabas ang gamit, ipapadlock na lang. Kasi mas may security si lessor na ipadlock niya na hindi niya ilalabas yung gamit. Kasi kung ikaw si lessee at may mga gamit ka sa loob, hindi mo mailalabas yun hanggat hindi mo bayaran, di ba? Kasi hindi bubuksan yun ng lessor. So, babayaran mo na lang para may ilabas mo yung gamit mo. So, if I were the lessor, I'll just padlock the unit and I will not allow him to get his things inside the property. Can that be considered grave coercion? Hindi din. Because by grave coercion, it means there is no justification for holding on to your, meaning to say the accused has no justification from detaining your things. Okay? But in this case, there is a justification, and that is the stipulation of the parties under the contract. Alright, what are the rules respecting improvements introduced by the lessee? So, ito na. Yung sasabi ko na, what if the lessee wants to improve the property? Kasi nga, let's say, it's a long-term lease. Bawa sabihin natin, 20 years. Long-term na ba yun? Okay. Long-term relationship, 2 months. Okay. And then, pag relationship, long-term na yung 1 month. Okay. So, anyway, lease ang pinag-usapan natin. So, long-term yan. So, let's say, 20 years. So, pagka 20 years, ganyan, if you're the lessee, could you could you resist making improvements in the property? I mean, day in and day out, you're seeing the same setup and all that. Kasi may isip mo siguro, ay gusto ko palitan, gusto ko mag-rearrange, gusto ko maglagay ng cubicles, gusto ko maglagay ng kung ano, di ba? Bawa ay countertop here, countertop there, ganyan, and all that. But of course, pag furniture yan, walang problema. But what we are talking about are the improvements that will alter the physical makeup of the property. Like, maglagay ka ng second floor, maglagay ka third floor, maglagay ka ng garahe, ganyan. So, what's the rule? What if the contract is already terminated? So, what happens to the improvements? So, read Article 1678, and here the Supreme Court, here the Civil Code provides that if the lessee makes, in good faith, useful improvements which are suitable to the use for which the lease is intended without altering the property lease, then the lessor may pay half of the value of the property or of the improvements, or allow the lessee to remove the improvements, okay, without further damage to the property at the option of the lessor. So in other words, si lessor ang pipili. So sa tingin niya, well, I don't need this property, so sige, pwede mo nang tanggalin yan. Or, okay, I need these improvements. Mukhang okay yung nilagay niyang mga cubicles sa unit. Okay? So, I could lease this out to another person who would be using the same for, let's say, an office or whatever, similar to my previous lessee. So, I would keep those improvements. So, in that case, pwede niyang kunin yun, pero kailangan niyang bayaran ang lessee by 50% or half of the value of those improvements. But if he doesn't want to spend, then pwede niyang patanggal, provided that the principal thing is not further damaged. Okay? Note that Article 1678 gives the lessor and not the lessee the option. So, hindi pwedeng si lessee ang mag-suggest or mag-insist na bilhin mo na lang to, bayaran mo ng 50%. Okay? So, hindi pwede. He cannot impose that on the lessor. The lessor has the option. But of course, the lessee naman is free to suggest. Sabihin niya, baka kailangan mo to, bilhin mo na lang to, ganyan. Pero kung ayaw mo naman, okay lang, tanggalin ko na lang. Okay. I-defense mechanism na lang niya. Sabihin na lang niya na, alam mo, kailangan mo to. Alam ko marami dito naghahanap ng ganitong area. So, bilhin mo na lang sa akin to ng 50%. Ayun, ganun lang kadali yun. Okay, now, speaking of good faith or bad faith, okay, if the lessee, okay, places them in bad faith, meaning to say, he knew that, of course, he could lose these properties or these improvements, and yet he introduced these improvements, and then to make it difficult for him to remove them without damaging the principal thing. Halimbawa, naglagay siya ng third floor. Okay. Siyempre, di mo naman po rin tanggalin yung third floor without damaging the second floor or worse, the entire building. And yet, ginawa pa rin niya. Okay. Next naman is, halimbawa, against the orders of the lessor, ginawa pa din niya. Halimbawa, sabi ng lessor, huwag ka maglalagay ng garahe dyan kasi mag-i-extend ako dyan, maglalagay akong extra room dyan. Pero ginawan pa rin niya ng garahe. So, in bad faith siya doon. So, in that case, the lessee loses everything. What's the basis? Well, the basis is your law on property on BPS, builder, planter, sower. So, a builder, planter, sower in bad faith loses everything that he has planted, sowed, or introduced into the property. Okay, last thing to remember is that when the choice has been made, okay, when the choice has been made, and let's say the lessor gave the lessee the right to remove the improvements, and yet he failed to remove the improvements despite reasonable opportunity to remove them, that would now operate as a waiver or abandonment of the improvements, in which case the lessor can appropriate these improvements without any obligation to pay one half of the value of those improvements. Okay? Ayan. Kasi abandonment na ang result nun. Okay, next. Is a lessee a builder in good faith with right of reimbursement provided under Article 448 and 546 of the Civil Code? The answer is no, because we have a special law, and that is Article 1678, and 1678 provides that only 50% will be refunded to a lessee. It's a different case when it is a BPS under Article 448 of the Civil Code, because Article 448 is the rule on property, and dun kasi ang basis doon ng entry to the property is lack of knowledge that the property belongs to another person. Pero in a contract of lease kasi, as a lessee, alam mo na kung sino yung may-ari eh. So you don't apply Article 448. You apply instead Article 1678. Okay? Now, what is tacit reconduction or implied new lease? So, tacit reconduction or implied new lease is that situation when the contract is impliedly renewed, okay, after the lessee has stayed in the premises for at least 5 days without any demand to vacate from the lessor. Okay, so in that case, nagkaroon ng implied new lease. Okay, but since this is an implied new lease, it will now be subject to a new term. Okay, so yung term na yon, we will now base it on the earlier rule that in case the term is not agreed upon in the contract, then the term may be using as reference the rentals. So if the rentals paid in this implied new lease is per day, then ang implied new lease is only up to the time or up to the day when the rentals have been paid. So kung nagbayad siya ng 5,000 at 1,000 pesos per day, then ibig sabihin nag-extend lang siya ng lease for additional 5 days. Okay? So para ka lang nagrenta ng room sa isang hotel, 'di ba? So gusto mo mag-extend pa, ayaw pang mag-check out, so magbabayad ka ng pang isang araw. So ibig sabihin na-extend ng isang araw yung stay mo doon sa hotel or resort, as a case may be. Okay. So what are the requisites of tacit reconduction? So take note that the term of the original contract has already expired, the lessor has not given the lessee a demand or a notice to vacate, and the lessee continued enjoying the thing leased for 15 days, hindi pala 5 days, okay, 15 days, with the acquiescence or tolerance of the lessor. Alright, so take note that the tacit renewal is not a contract without a term, because the term would be based on, as we have said, the days or the value of the rent paid. Now also the term of the original contract which are renewed is only with respect to the possession. So all other accidental provisions or stipulations are not carried over. So for example, in the first lease, there was an option to buy or a right of first refusal. So that option to buy or right of first refusal is not carried over in the implied new lease. Sa implied new lease, yung principal right of possession lang ang nare-renew. And also, of course, the counterpart obligation of the lessee to pay the rent. Okay, so renewal of lease and increase of rentals. Okay, so take note that both renewal of lease and increase of rentals should be subject to the consent or agreement of the parties. So these matters cannot be imposed unilaterally by the lessor. Okay, because again, all terms of the contract, including the rentals, must be agreed upon by the parties pursuant to the mutuality of the contract. Okay? Hindi pwedeng unilaterally tataasan ni lessor yung rent. Kailangan may due notice para at least makapag-prepare si lessee. At saka kung hindi naman niya kaya, meron siyang sufficient time to vacate the premises or to look for another place to transfer. Okay, so that's it. Natapos din Ayan. I promised, or my plan was only for 2 hours. 1 hour each for sales and lease, pero umabot tayo ng almost 4 hours. 3 hours lang pala. 1, 2, 3, 4. Okay, but I enjoyed every minute of this, and I hope you also learned something from the lecture. By the way, I am also on Facebook. If you haven't followed me yet, my Facebook page is Attorney Al Jumrani, and of course this is my YouTube channel. This is the House of Law, and so I hope you will watch my videos, subscribe to my channel, and then click that notification bell so that you will be notified in case I upload a new video. Okay, so by the way, I'd like to give a shout out to sino pa ba ang pinakahuling nag-comment dito, and si Marnil Rosa. Okay, yeah, hi Marnil, I think you are a follower na, no, subscriber na sa aking channel. Yeah, madalas ka po mag-comment, and I like your comments. Medyo out of the box, but YouTube is a free space, so I'm glad that you are actively following me and making comments. Okay, so that's it. So just stay tuned for my lecture tomorrow. I will give the link to Miss Rose, and of course, if you're following my channel, then you will be able to get the notification once I go live again tomorrow afternoon. And tomorrow I will be talking about loans and deposit. Okay, so again, thank you for watching. This is me, Attorney Al again. Laging tatandaan, isip ay buksan, alamin ang batas.